Morning.
All right, we'll get started here in a moment. I accidentally, well, I didn't accidentally. I had to kick everybody out. Sorry, Miss Blue. Sorry about that.
It's all right.
Okay. I'm good now, though. Let me, do we have the defendant, Mr. Seeger? Is he?
I think he's trying to join us. He at least contacted me and was asking for the Zoom code, so I sent it to him. So I assume he's going to appear.
Okay. We'll just wait till he gets here, and then I'll grab the judge, and we'll get started. This might be him. Is that you, Mr. Larson? Mr. Larson, can you hear us?
Oh, there we go. Can you hear me?
We can. You're Mr.
Right.
Larson, right?
Yes, Your Honor.
That's how you spell it. All right, let me get the judge and we'll get started. Judge, ready when you are. Thank you. All right, I'll be out in a sec. Oh, shoot. Oh.
Good morning. This is People versus Jonathan Larson, file 2045553. SM and Mr. Seeger is here on behalf of Mr. Larson, Ms. Blue for the People. And this is the date set for a plea. Mr. Seeger, is that what your client wishes to do? And is there a plea offer?
Yes, Your Honor. Your Honor, it's my understanding that Mr. Corky Carter Larson is going to plead guilty under the deferral. Additionally, Your Honor, and I'm not sure if the new statute has changed this related to like probationary terms, but he would stipulate and agree to a period of 1 year of probation to receive the benefit of the deferral. And I'm not really sure how the court is handling that per se, but with the new statute. But in any event, that's the agreement, Your Honor.
I'm glad you mentioned that, because the way I've been handling it, and I could be wrong about this, but I've been telling the defendants that they have a right to petition the court after the first 6 months of a 1 year probationary period. Now, because this is a plea bargain situation, and the prosecutor has to agree to the deferral, I believe the prosecutor could refuse to dismiss the case prior to the 1 year mark. So, and perhaps the prosecutor could enforce the plea bargain as well, but that's what I've been doing. I haven't been challenged by the prosecutor on that. Generally, though, it's been in, I've been doing it with retail fraud cases, but on delays. So that's the approach I've taken, is again to allow the review at 6 months. But again, I think the prosecutor probably does have the right to enforce its plea bargain. So,
and Your Honor, just and I'm not engaging in a legal argument of any kind, nor am I questioning the the authority of the court. The only thing that I would note that is the prosecuting attorney does not have to consent to the deferral. That's a function of the court. They can consent to it, but it's not statutorily required that they endorse it. That is a function of the court because it's a sentencing component. So if the court is allowing him to have the ability to review it within 6 months, then I guess that's the case. Because as I've always understood it, it's not a sentencing agreement per se. It is a recommendation by the prosecuting attorney's office, which I guess the court has somewhat construed as a sentencing agreement. But for what that's worth, Your Honor, consistent with the new statute, it's just a question of I'm not entirely sure how the court is handling it. But it does make sense what you're saying in terms of like a retail fraud and a delay, wherein they may want a period of 1 year of a delay with a dismissal or something of that nature. That might be somewhat distinguishable, I suppose.
I think you've described the issue well and framed the issue well. And so I don't know if Ms. Blue has any comments on that well, I guess, first of all, Ms. Blue, is that the plea bargain in this case? And any comment on the 6-month review?
That is the plea agreement, Your Honor, and it is our position that we are asking for a 1-year probationary term to the extent that we're able. Part of that is the completion of the men's group, which takes at least 9 months for the 36-week program. So that's, part of the issue. And then we are asking for the 1-year term as it relates to the benefit of the deferral.
Well, she's obviously got a good point there. Unless a defendant were to start the men's program early, which sometimes does happen, it would be unlikely they would be able to complete that program sooner than 9 months. But at the same time, I think Mr. Seeger's right. This court's never engaged in Cobb's agreements, which would be an enforceable agreement. And this has always been kind of a loosely agreed upon course that the prosecutor recommends a 1-year probation. The court's gone along with it. That's what this would be, no doubt, is a 1-year probationary period. But the question is whether or not the defendant's entitled to a review at 6 months, since he's not going to complete the men's program within that time, most likely. Then the issue really isn't, well, there's no real issue here. I think the bigger issue is what about when he does complete the men's program? Would the prosecutor be required to dismiss at 9 months if the court were to take him off probation? I don't know. I would want to see briefs on that issue. And so that's all I can tell you. And I don't know if you want to talk to your client some more about that before entering a plea, or if you're prepared to go forward, Mr. Seeger.
I guess that's up to Mr. Larson, Your Honor. And I think that if it was consistent with the statute, that if the court wanted to review it, I think the court has the authority to review whatever its sentence is at any time because of the circumstance. Ordinarily, it would be a final judgment, but because it's under a deferred status, I think that the court has the ability to review it at any time. But if Mr. Larson wishes to speak about it, then if the court wants to put us in a breakout room, I can describe it to him.
All right. Well, I think since we've had a lengthy discussion about this, Mr. Larson's probably wondering what's going on here. So I think it'd be a good idea to put him in a breakout room. So I'm just going to go ahead and do that rather than put him on the spot.
There you are.
All right. I will say before I do that as I see the new legislation, the intent is that once all of the rehabilitative purposes of a probation have been met, that the court should consider releasing a defendant from supervision. That's the way I'm looking at it. And with that, there will be an invitation on your screen, Mr. Larson. You want to accept that to get in the breakout room. What about?
Good morning. Remember, you get up at 9 o'clock, Mr. Showman, for a sentencing.
Yeah.
And I've been over at the jail this morning, and he's been a stinker over there, so they just wanted me to make sure that I gave you a heads up that he could show his colors. He's threatening to lash out over there, so.
Okay. Well, I'm safely on the bench.
I just want to give you a heads up in case he starts becoming a flathead on the Zoom.
Okay. All right. Well, thanks for the heads up.
He goes in front of Judge Stepka today too, so.
Does he? Okay.
It's a plea for him on a retail fraud.
Okay. I'm gonna go grab the phone. All right, we've got the defendant and Mr. Seeger back. So are we going to go ahead with a plea today, Mr. Seeger?
Yes, sir.
Okay. All right, well, Mr. Larson, the plea agreement has been described. And is there anything else that you've been offered to get you to plead guilty that hasn't been disclosed on the record?
No, Your Honor.
And have you been threatened, forced, or forced in any way to get you to plead guilty?
No, Your Honor.
Do you understand that typically I would go along with the prosecutor's agreement, which is a 1-year probation. And if you complete all the conditions of the probation successfully, there would be no conviction at the end of this. And typically you wouldn't receive any additional jail time. On the flip side, if you violate the conditions of probation, a conviction may enter and you could be sentenced to up to 93 days in jail. Do you understand all that?
Yes, Your Honor.
All right. Let's see. Has Mr. Seeger answered all of your questions to your satisfaction?
Yes, Your Honor.
I see you signed an advice of rights form back on April 6th. That form described all of your trial rights that you'd be giving up if you plead guilty. Did you read and understand all those rights before you signed the form?
Yes, Your Honor.
And do you wish to waive all those rights in order to plead guilty with the understanding it would be a deferred sentence?
Yes, Your Honor.
All right, so I'm going to go to the complaint then at this time, and it alleges that on December 1st of 2020, you were at an address on Lilac Lane in Garfield Township and Grand Traverse County when the incident occurred. Is that true?
Yes, Your Honor.
It says that you were with Jennifer Zietz, a resident or former resident of your household, and someone who you also had a child in common with. Is that true?
Yes, Your Honor.
And did you make an assault on Miss Zietz?
I pushed her out of the way, and it was not self-defense, Your Honor.
Okay. And it wasn't an accident or just playing around. She would have been offended by it.
Yes, Your Honor.
Okay. All right, then, to the charge of domestic violence, how do you plead?
Guilty, Your Honor.
All right, I'll accept your plea. Find it's voluntary, accurate, and understand. We'll set this for sentencing at a later date, and Ms. Odom will work with Mr. Seeger to set that up.
How about Thursday, June 10th at 9:30?
Is there another date? I apparently have currently 2 trials scheduled for that day. I don't know if they're going or not, but
Yeah, sure. How about the 17th
the
at
17th
9?
the 17th at 9 would presumably be fine, or at least currently it would be fine.
Okay.
All right, so we're going to be back on the 17th at, you said 9 o'clock?
Mm-hmm.
Okay, 9 o'clock. And prior to that time, I do need to get a pre-sentence investigation report done. And I'm going to need you to recall the probation office, Mr. Larson. I'll give you a phone number here. Let me know when you're ready to write that down.
Yes, Your Honor. 1 minute.
Yeah, take your time.
All right, and that phone number is going to be
231-922-5600.
922
6899.
6899.
That's it. Please call after 1 o'clock today. That way they'll have the paperwork from this morning's hearing.
Okay.
And I'd also like to ask the attorneys, would it make sense to get a substance use assessment in this case?
I believe so, Your Honor. I was going to address that. Part of the victim's statement to law enforcement that evening was that there was an argument about drug use.
Okay, well, we'll go ahead and do that. And is there anything else that we need to take up today?
Not from the people.
Okay, thank you. We're all set. Feel free to sign off at this time, Mr. Larson.
Thank you, Your Honor.
Okay, Ms. Blue, are you familiar with Mr. Harrison's case? He's set for a couple motion hearings this morning. I think it's regarding bond. It's not a domestic violence case. It's threatening or malicious use of telephone services. And it's my understanding he's in the hospital. And so we won't be able to conduct a hearing on those.
Okay. It looks like Miss Mogenberg was scheduled for us, so I can let her know if the court's not going to hear that today.
Well, and Mr. Kane was just appointed yesterday. I just
Was
found
he?
that, or to this morning. Yeah.
Okay. Well, I'm going to assume that that's off unless I hear from Ms. Mogenberg or Mr. Kane that there's something we need to take up today. So, okay, thank you.
Thank you.
All right, and our next case is 9 o'clock Rudy Showman.
Should I reset the motions? I need to look at the motions. At this point, I wonder.
Really a motion or just a bond?
No, there were two motions filed a while back. Let's look. I think. There's the order. There's bond. Yeah, People's Emergency Motion for Bond Review. You know, let me see something.
Well, I think that probably had to do with the hospitalization. So it's kind of been resolved that way.
Yeah, I kind of feel like that too.
Okay.
I'm gonna wait and see if there's reason, but it does. I think it's been resolved. Let's see what it says.
Yeah, I would just email the attorneys and ask if there's any reason to reset that.
Okay, I will. I'll do it right now.
Okay. Well, let me know when Mr. Showman and Mr. Connolly show up.
Okay, I will.
Hey, Tammy.
Yeah.
Is Miss
Yes,
Bose
ma'am.
still on for 9 o'clock?
Say that again. You faded in and out.
Sorry, Ms. Bosak.
Oh yeah, she's on for 10:15.
Oh, 10:15. Okay.
Mm-hmm. Hi, Mr. Conley.
Good morning. How are you?
Morning. I'm doing pretty well. How about you?
Good, good.
I don't think so. I think we need the jail.
Oh.
Do we need the jail for Mr. Showman?
Yeah.
Yeah. So
Is he in jail?
Yeah, and he's not doing well over there, apparently.
Oh,
You might
okay.
want to have a break. I don't know if you need a breakout room with him or not.
Yeah, I do, for sure. I didn't know he was in the jail. So,
Yep, all right. Yeah, they've had some issues with him over there.
Uh-oh.
Could you get Mr. Showman ready to
Yeah.
in front of Judge Cooney, please? Thank you.
Thank you.
You're welcome.
Do you represent him on his other case that's going today?
yeah.
Okay. Apparently, Mr. Showman has a new felony case.
Oh, for what?
I don't know. I'll look it up for you. It should be arraigned at 1 p.m.
Okay.
I'll look it up for you though.
Probably RNO.
Could be 5. Assault of a prison employee. An
Oof.
offender. 4. So, where was he?
It would be the jail. That must be what you were talking about. He must have got into it with one of the officers at the jail.
All right. Okay. There you go. Might have been a potential spit in the face.
What's that?
It's an alleged spit in the face.
Oh, yeah. Nobody likes spitting.
Good Lord.
Yeah.
Temper.
Yeah. I was close. It was close to an R&O. It could charge it that way, I suppose.
Yeah.
Do you have any prelims going today, or is it pretty
It
smooth?
looks like waiver. Looks like it's going to be a waiver and possible misdemeanor plea, and then one guy's unrepresented that I know of. I've got to check that out.
On a felony case?
Yeah, that happens a lot,
Huh.
believe it or not. Then it gets adjourned, and then he gets talked. I don't want to say talked into, but ends up requesting an attorney. You know.
He's reasoned with.
Exactly. You might want to rethink that.
Yep.
But go ahead.
I can't even imagine
Yeah.
being a judge and dealing with a felony trial with an unrepresented defendant. That would be a nightmare.
I've never heard of it, but I wonder if it's ever happened. Sure
I
it
know
has.
Paul Jarbeau one time was what they call standby counsel. So he just sat there and the client conducted his own felony trial. So
Holy moly.
yeah, with the result you would anticipate.
I feel like I remember that, but oh no, I wouldn't. It's not a felony trial. I wouldn't. Oh my
Well, you
gosh.
might
How did we get?
probably saw the prelim though. You know, I mean, it had to come through you guys to get there.
Yeah. Exactly. All right, I'm gonna put you in a breakout room.
Okay, thanks.
Welcome. There you are. Okay, let me see here.
So Mr. Showman is going to move forward on his own, apparently.
Oh, okay. So I'll get him out of the breakout room and we will, yeah. Get the judge back in here. Did you hear that? All right, we're ready when you're ready. Oh, there we go. That was nice.
All right, this is People versus Lee Shulman, file 2146889SM. And Mr. Shulman is here with his attorney, Mr. Connolly. I believe, I thought Ms. Blue was going to be here, but I guess not. Ms. Morton is here from our probation office. This is the date set for sentencing on the defendant's conviction of one count of attempted resistant obstructive police officer. So, Mr. Connolly, have you had an opportunity to review the pre-sentence report with your client, and is it accurate and complete?
Your Honor, Mr. Shulman does not wish to speak with me or have me represent him. So I'm not sure what to do there. Perhaps you can ask him how he wants to proceed, but he's refusing to talk to me. So.
Okay, so Mr. Shulman, are you having difficulty with your relationship with your attorney? Are you requesting a new attorney, or how do you want to proceed?
I thought ain't this sentencing?
For sentencing, how do you wish to proceed? Because Mr. Connolly is here, he's ready to represent you.
Ain't it for sentencing? Ain't you supposed to just give me how many days I'm going to be in jail, and that's how that works?
Well,
this is sentencing, right? Sentence me, dude. Right? Okay. I don't know how this works. You're the judge. You're supposed to sentence me, ain't you? Well, why you guys are asking me like I got an option or something?
Okay. You
give me how many days I'm going to be in jail, and we'll be done here, right?
Mr. Shulman, I'm going to mute you at this time, because this is not your chance to just rattle on about whatever you want. Okay? You are given an attorney at the public's expense to represent you. And Mr. Connolly is here. He's ready to talk to you, to go over the pre-sentence report with you and discuss that. And you're not working with him. Now, if there's a problem with you and Mr. Connolly working together, if the relationship is broken down, Mr. Shulman, I've got you muted, so I'm not hearing anything you're saying, because it has nothing to do with the hearing today. Now, we're going to have to adjourn the hearing because you're not cooperating. And frankly, I don't know what you want to do. I can't proceed without knowing whether you want an attorney, whether you want to fire Mr. Connolly and proceed on your own, whether you want a new attorney, but you're going to have to calm yourself down and figure that out. So the hearing is adjourned for today, and we'll set this up for, say, a week from now. And maybe you'll take some time and talk to your attorney, but we can't proceed if you're not going to answer the court's questions. I'll be in recess until the next hearing.
Okay.
Yes, Your Honor. Yes, Your Honor.
We have next Sumner. Okay. All right. You going?
Yeah, I'm gonna run over to Judge Stepka's office.
All righty.
Real quick.
Sounds good. Better do this today. Okay. People agree. Dismissing pending misdemeanor 5092. Okay. And then what's this case? O2. No. 214841. Yeah. Hi, Miss Sumner.
Hello.
Hi. We're waiting for Mr. Graff. Mr. Graff, are you in the background there? And Mr. Hamlin,
Yes,
are
I'm
you here? Okay.
Yep, we're both here.
Okay, Mr. Graff, do you need a moment with your client or are you ready to get going?
I believe we're ready.
Okay. Oh, come on. Hi. Can you tell the clerk when you're ready? Okay, thank you.
All right, this is file 204533FY, People versus Kirsten Sumner. And Ms. Sumner is here with her attorney, Mr. Graff, and Mr. Hamlin is here for the people. Ms. Morton is here for the probation office. This is the date and time set for sentencing. The defendant's conviction of use of a controlled substance. And let's see. Mr. Graff, I was concerned because in the body of the report under incident, it indicates that the defendant only pled guilty because she was encouraged to do so by her attorney. She said that these weren't her drugs. Now, I know later in the report it indicates she admitted to using. And I guess, does the defendant wish to withdraw her plea?
Not that I'm aware of, Your Honor. She has a copy of the report. We've talked about it, but I guess we can confirm that on the record if she wants to change her position.
Okay, so Ms. Sumner, I haven't sentenced you yet, and so typically I would be very liberal about granting a request to withdraw a plea. I do realize that this was a use case, not a possession, so I suppose it's not inconsistent that the defendant admitted several times she was using methamphetamine, but denied that the drugs in the home were hers. So that's not inconsistent. But Ms. Sumner, if you want to withdraw your plea, I'm fine with that. What do you want to do?
We're gonna continue with what we're already doing.
Okay. Ms. Sumner, I'm concerned because you both look and sound as though you're on something.
No, I have a cold going on. I have like laryngitis from the allergies or something.
Okay. Mr. Graff, have you had an opportunity to speak with Ms. Sumner this morning?
Not this morning, Your Honor. I can confirm her voice sounds exactly as it has since I originally met her. It has always been a raspy, low-tone voice.
Okay. You haven't consumed any drugs or alcohol this morning, have you, Ms. Sumner?
No, I just got up a little bit ago. Been up for like 30 minutes.
Okay. I'm asking because I don't sentence people if I have a concern that maybe they're not completely aware of what's going on. And but you're saying you haven't consumed any alcohol, no non-prescribed medications, and you do understand what's going on. Is that correct?
That's correct.
All right. And the sleepiness or whatever is going on, that's because of your cold?
I've got some sinus something going on where it's draining down my throat. And I've had a sore throat for a few weeks. And I've been fighting it with allergy meds, but it's not getting a whole lot better when the pollen's blowing everywhere.
All right. Well, I'm satisfied that Ms. Sumner is alert, and even though she's apparently got a bad cold or allergies, that she's able to fully participate in the hearing this morning. Do either of the attorneys have any concerns about that?
No concerns from the people, sir.
I don't have any concerns, Your Honor.
All right. Okay, so Mr. Graff, have you had an opportunity to go over the pre-sentence report with your client, and is it accurate and complete?
We have, Your Honor. We talked about it twice yesterday, once in the morning and once in the evening. The only correction we have aside from allocution is, I believe, if we look at the stip in order to remand, it was to use of a controlled substance, dismiss the misdemeanor cases, but it was restitution in the other misdemeanor case. That would be 20-3836, where the restitution amount was $2,110.41. So it looks like they may have been flipped, the two misdemeanors and what she's supposed to pay restitution for, but those were both dismissed and she's supposed to pay that greater sum of restitution.
All right, so you're saying the case number that's listed there is the wrong one?
It is, as well as the amount. Obviously, $191 is much less than what we agreed to, but we did make an agreement, and that agreement was to $2,110.41.
All right, and what's the case number for the misdemeanor that was dismissed?
Both files 20-3676 were dismissed, as well as 20-3836. The restitution was in 3836.
Okay, so the $191.52, that's not being requested at all then?
That was not part of the agreement that we had reached, no.
Part
That
of
is
the
correct,
agreement. Okay. All right, so that's all correct then, Mr. Hamlin?
Yes, Your Honor, that is correct.
All right, thank you. All right, we should correct the pre-sentence report to reflect those changes. So it's where it says conviction, rather than file 203676, it should say 203836. And the restitution figure under the sentencing recommendation should be $2,110.41. It should also indicate in the report that file 203676 SM1 was dismissed as a result of the plea in this case, which brings up a question I have. What were those cases about?
I did not represent Ms. Sumner, Your Honor. I believe the case that we agreed to pay restitution was regarding an animal. The other case may have been a retail fraud, if I'm correct. I'm guessing though.
Mr. Hamlin, are you able to help us with that?
Yes, Your Honor. In file 3676, that was a retail fraud third degree. And then 3836 was animal cruelty, the standard abandonment for 2 to 3 animals, sir.
Mm-hmm. In this case that we're sentencing on is 204533, and I haven't heard that case number yet. Is that correct?
Yes.
Thank you.
Okay, so any other changes or additions to the report, Mr. Graham?
No, Your Honor, just allocution.
Okay, so go ahead.
Thank you, Your Honor. Your Honor, there's obviously a lot to unpack here, and Your Honor sat through a joint prelim between Ms. Sumner and one of her co-defendants, Ms. Chili, and I'm not going to rehash all of that, but I do feel it important to point out a few things that have come to our attention since that time, just in order to make sure the court has a full, I guess, picture of some of the facts and why there may be a disconnect in the PSI. Subsequent to the preliminary examination, we received the pictures that were taken as a part of this investigation. And some of those pictures are consistent with some of the positions that Ms. Sumner has made since day one. We submitted 3 statements regarding the fact that her child had been living with her parents for approximately 6 months at the time of this incident. And if you recall, some of the facts that the preliminary examination that were admitted were that it was the police were informed that the child had been living there. And obviously these completely contradict that. The court may recall this case was adjourned because at one point I was considering actually calling witnesses at the preliminary examination. And so those are letters that we had compiled regarding their potential testimony, which were provided to the people. Prior to that, we ultimately decided not to. But when we received the pictures, Your Honor, they alerted me a few things that were inconsistent with some of the testimony. If the court recalls at the preliminary examination, there was testimony by 3 officers, and they all testified that the room that they found these narcotics and associated with Ms. Sumner, they were able to identify the room because there was a picture on the wall of her. And we're not disputing the fact that obviously she's guilty of what she pled guilty to. We're not trying to rehash all those facts. But when I reviewed the pictures, there was over 100 pictures. There was no picture that they had taken of a picture of her on the wall. And they were all adamant about that. And I also asked about identifying information in the room, and they all weren't aware of any identifying information. And specifically, Officer Lesner testified he was the one who was in charge of this room. And in fact, I asked him whether or not there was identifying information for anyone else in there, and he didn't know. Yeah, he was in charge of that room. When I got the pictures, I looked through, and when they went through the safes in which drugs were found, there was a title to a car of somebody else. But more importantly, there were a couple of bank receipts from an Andrew Hughes from an August 7th, which was less than a month prior to this incident. And I think that would be important, obviously, to identify other people that were using the room in the house. And so I wanted to point this out for the court, not to go back through all the facts of the case. I know we are Davenport at the time of the prelim, and we're not asking to go back and rehash that. But again, when we read the PSI, there's a real disconnect on the understanding of whether or not Ms. Sumner takes responsibility for what's going on. And that's why I thought it was important to point some of these things out, that her position is actually a little more consistent with some of the information we have now. That said, she was living there prior to this. And obviously, as she was indicated to the assessor, I thought she was quite candid in her reflection of her use history. The court will note from the PSI that other than an MIP in 1999, and then again in 2004, an MIP and a driver's license suspended, she has no other record. Unfortunately, she came before the court on some very serious charges here. But there's information that maybe she wasn't being forthright. Well, we don't have any other information regarding Ms. Sumner's use patterns other than what she's told the assessor. And I thought she was pretty blunt. She said from May 2020 until August 2020 that she did anything and everything until their friend died from an overdose, and she got clean from all substances except medical marijuana. She reported in that time period she used methamphetamine on a daily basis, and that her first use ever was in May 2020. She reported she tried cocaine once in her early 20s and that she used it whenever she could between May and August 2020. She reported between May and August she used heroin twice. That's a pretty candid response when you say, what are her use patterns? I mean, she talked about using things daily whenever she get her hands on. I don't know if we get more a blunt answer than that. She could have sugarcoated it and we may not have known. But I think that reflects somebody who's taking the issues here very seriously. She relocated from that house downstate with her boyfriend in order to get away from the situation because she saw her life spiraling out of control. From what she's explained to me, things are completely different as opposed to when they were last fall when all this happened. She's been living down there. She's thriving and doing well. As far as I understand things, she told me that not only is she working at the Beacon Specialized Living location, she just received a promotion at work, and they still want to work with her despite the fact there could be some licensing issues. And so I think that speaks to obviously her as a person of how important she is there and how well she is doing. She's been on bond for a period of time now. I know there were comments about the potential for the amount of testing, but if she had a significant problem which she was trying to hide, I'm sure we would have found out by now. So I think that Ms. Sumner understands the significance of the events. I think she's taken proper steps on extricating herself from that situation. And if she doesn't get some things under control, obviously she may not get her children back. She may not be a part of their lives. And incarceration could be on the forefront. Obviously, if she were to get in trouble for significant substances again, it would probably cost her a job, probably cost her a career. She'd probably end up going to jail, if not prison. And so I think we have somebody here at a turning point who's made the right steps in the past. She's moved on to bigger and better things down in Branch, Michigan. I think that she's been as compliant as she can with the bond. She was up front when she talked about the prices and the difficulty it was to test, but she was still doing her best to make that happen. I don't have the information that she's missed or test positive throughout this entire time. I don't have the results, and I could be ahead of myself, but I'm not sure that even she tested positive on her benchmark. And so I guess, Your Honor, I would ask the court to consider imposing a probationary sentence, giving Ms. Sumner the opportunity to prove herself to this court that she is serious and she is making better changes, and that her use, although out of control back then, she is not living that same lifestyle. With the full understanding that she doesn't follow through with the terms of probation, things are going to get much worse for her, that she's got a year of jail that she could potentially serve. And obviously, if she serves any amount of time in jail, that'll probably result in the loss of her job and more significant problems. But again, I think that some of the recommendations here about maybe some educational tools, maybe some oversight might be a good thing for her to make sure if there are any lingering issues that she properly addresses those. But I would hate to see somebody for offenses that occurred approximately 8 or 9 months ago, go to jail, lose her job, and have to totally start over when she has made a lot of those changes already. And so, Your Honor, I would ask the court to consider placing her on probation and giving her that opportunity. And if the court believes that jail time is appropriate, to hold it in abeyance or over her head, so if there are any violations, she knows exactly what's coming.
Okay, thank you, Mr. Graff. Ms. Sumner, I would like to hear from you. Is there anything you'd like to say before I decide on a sentence?
No, I'm just trying to do better for myself and my kids. I moved away from everybody and everything I knew, I got a good career. I live a normal, boring life, work and come home and do it all over again every day. I mean, I've never been in trouble like this. I don't plan on ever doing it again. I understand I screwed up and I'm willing to admit to that and take responsibility for it. But, you know, and I've been on bond for almost a year on one of the other cases, and I've followed the rules. I've done all my testing. I've done everything that I'm supposed to do, and I plan to continue to do that for successful probation.
Okay. And I think it's important for you to understand that, you know, it sounds like there are some flaws with this case. Maybe you weren't actually caught in possession of methamphetamine, but I think it's almost beside the point. There's no doubt, based on your statements to Ms. Taylor and the person at Catholic Human Services, you were a heavy user of methamphetamine for about 4 months last summer. And the thing about that is people generally don't just quit meth and cold turkey and the problem goes away. That's why I think probation is going to make sense for you. You know, you need to stay on top of this because you had a problem at least at one time. And even though, as you say, your test results have been negative, Ms. Taylor's got some real concerns about whether you really haven't been using, but there's no evidence to suggest otherwise. But still, I see people relapse all the time when they were using heavy drugs like methamphetamine, especially. And this is just something you got to stay on top of. And so whether you were caught red-handed or not, you know, that's really not the issue for you going forward. It's maintaining your sobriety, because that's important to your 14-year-old son. It's important to maintaining, you know, everything you've got, your job that you enjoy and that sort of thing. So anyhow, I appreciate your comments. And Mr. Hamlin, is there anything you'd like to say?
Well, Your Honor, the only reason I wanted to appear is because after reading the PSI, I obviously had some concerns about whether, you know, the claim is still being made that she wasn't staying at the house and that kind of thing. I didn't do the prelim in this case, so I wasn't there for the testimony, but there was an overdose the week prior to this incident happening. It was a Monday morning at 6 in the morning when that was called in, and she was awoken out of her bed for that incident. And at least some children were staying in the house according to the report for that day. So along with the co-defendants from this case when they were interviewed, stating that she did reside there. So I just wanted to make sure the court was aware of that. Thank you.
Okay. All right. Well, thank you. All right. Well, this is sentencing on defendant's conviction of use of methamphetamine. And the facts are that the defendant, who apparently had picked up a couple of other charges, the animal cruelty and retail fraud cases, it was, I guess those cases are consistent with what was going on here, the use of methamphetamine or other drugs. And the defendant, there was a raid done on the house where the defendant was living, and there was reportedly methamphetamine found on her bed and dresser. Now it's contested by the defendant whether that was actually her bedroom or not. And again, I'm just going to repeat that that's neither here nor there at this point. The defendant has pled to use, and She did admit that from May 2020 to August 2020, she was using meth every day, she said. I agree with Mr. Graff that Ms. Sumner was very candid about that with both the probation officer and with Catholic Human Services. And so to me, whether or not it was her drugs on the bedroom dresser that day or not really doesn't matter too much. The defendant, to her credit, has been consistent in all of her bonds. I'm not aware of any violations. As Ms. Taylor points out, testing hasn't been the most rigorous, but at the same time, I think if the defendant were using, it would be very difficult for her to somehow have tested negative all this time. So, and there's no other evidence to indicate that she hasn't been clean, other than she does have a prescription for medical marijuana, and there's some reasons stated for that in the report. The only thing I would say about that is being a drug court, treatment court judge, what I've learned is people are 3 times more likely to relapse on narcotic drugs if they use marijuana. Those are just statistics out there. And so even though I discourage that use, I'm not allowed to prevent you from using marijuana if you have a prescription, which you do at this time. So, but keep that in mind. Maybe there's some other way to treat the pain that you have. I think it was some kind of shoulder pain or something like that. But anyhow, also to the defendant's credit, she is a lead staff professional at Beacon Specialized Living in Ludington. She's been there since mid-September, but she's been in that profession for about 7 years now. So Ms. Sumner is industrious, and she, I'm assuming, hardworking. You don't stay in that employment unless you're a hard worker and probably committed to what you're doing. And it's not easy work, but I always say it takes a special person to do that. So those are all positives. The defendant also has a 14-year-old son, as well as an 18-year-old son, and otherwise seems to be a productive citizen. I'm guessing that the overdose death back in August was the reason for moving and getting away from this whole situation that you were living in. And that's also to your credit that you decided you wanted a different lifestyle. And after seeing that happened, I'm concerned by the substance use assessment because Ms. Sumner, it says that you have a severe substance use disorder, and it's not common that I see severe used. And Catholic Human Services, I think, is pretty good at being very conservative in its diagnoses, but that's what it reports. And that's probably because for at least 4 months there, you were using on a daily basis. The other concern I have is that your assessment score for desire to change is very low. And typically that would indicate someone that just doesn't care and thinks they can handle using drugs. But that isn't what I'm hearing here today, and it's not consistent with you testing negative. It sounds like you do have a desire to change. So For all of those reasons, I think the proper sentence in this case is probation. I do think that the longer term of probation, the 18 months, is appropriate given the evaluation, which indicates a severe substance use disorder. Our drug court program is up to 3 years of probation for the specific reason that it takes a long time for the brain to heal from an addiction issue like this, and before we can be reasonably certain that someone isn't going to reoffend. And I can tell you from experience, even after 3 years, people still of sobriety, people relapse and they die. Okay. Mr. Hamlin and I attended a funeral a couple months ago, or a month ago, as proof of that. So keep that in mind. So I think 18 months is appropriate. I might think about 2 years, except that the defendant has been on probation, bond for about a year now. Well, not a year, but since at least September, where she hasn't been using. And so the fine in this case is going to be $100. There's a $500 cost, 75 crime victims fund, 50 judicial system fee, and you'll need to repay the cost of your court-appointed attorney. That's the $250. The restitution that's been agreed upon is $2,110.41 in file 203836. The case is dismissed, as well as file 203676. As far as the conditions of probation, you're not to consume or be in possession of any alcohol. And that's for the same reason that I caution you about your use of marijuana. The death that I just spoke of started out with someone who had graduated drug court and thought, well, maybe now that they're off supervision, using a little alcohol would be okay. That soon turned into heroin and cocaine and other drugs, and then an overdose death. So that's why none of these substances are conducive to sustained recovery. So no alcohol, no use or possession of illegal drugs or mind or mood altering substances, including recreational marijuana, unless you have a prescription. You're not to consume or be in possession of any non-prescribed medications, and provide a copy of proof of that prescription to your probation officer within 48 hours of obtaining any prescription drug. You're not to reside where alcohol or drugs are present, and you're not to enter bars or casinos. I'm not going to extend that to restaurants that incidentally serve alcohol by the glass. So just bars and casinos are off limits. You're not to behave in a violent, threatening, intimidating, or harassing manner toward anyone. Be respectful of all court employees and care providers. You're to attend and complete the basic awareness group and follow all recommendations that's consistent with the diagnosis and the substance use evaluation, and take and pass a minimum of 4 times per month random drug screens. I know that's expensive, and if you continue to do well, your probation officer will have the discretion to reduce that testing at some point. But I think it's a good idea to start out making sure that we know what's going on. You need to also submit to any discretionary drug or alcohol testing requested by the court or law enforcement. I think given the what's going on here, the amount of conditions imposed. I'm not going to impose any additional community service work as is suggested, or jail time. But I am going to require a minimum of one time per week NA meeting. There's no involvement with that in the report, but I think it would be important for you to become involved in a 12-step program. It doesn't have to be NA. It has to be a 12-step or similar program that is acceptable to your probation officer as an alternative to the usual NA. So once per week meetings. Other than that, you need to notify your probation officer if you have any contacts with law enforcement. And I would consider amending the term of probation at the halfway point if all the terms and conditions have been completed. But I will say this, I'm unlikely to grant that at 9 months. I would have to be truly convinced that we've that there is no longer any concern about a relapse in this case. And so just letting you know that, but I would certainly be willing to consider it at the halfway point in the probation. All right, so we're all set then for today. Unless there's anything else for you, Mr. Graff?
Just a few questions, Your Honor.
Okay.
The first, and I guess I'd have to ask Ms. Sumner this, she can't have any non-prescribed medication. Ms. Sumner, do you have to give out or handle medications as a part of your job?
Yes.
Can she do that, Your Honor?
Yes, I will make an exception for handling those drugs during her work only, okay?
Thank you, Your Honor. And my next question would be, she lives in Branch, Michigan. Would she be allowed to, I guess, attend an equivalent of the basic awareness group somewhere closer to her?
Absolutely.
Okay.
Yeah. And I don't expect her to drive up here for counseling.
Okay. Thank you, Your Honor. And my last question would be, we addressed this during the pendency of the case regarding the testing. I'm sorry.
Yeah, with regard to the basic awareness group, it has to be something approved by her probation officer, however, okay?
Mm-hmm. Okay.
All right. What's the other issue?
The other issue, Your Honor, is we addressed this during the pendency of the case, and I think that might be why Ms. Taylor had some concerns. They're limited to no places to test in Branch. And I think one of the issues why there's no weekend testing was because the exorbitant amount it costs to test on the weekend. And so I guess I just want to bring that to the court's attention so that Ms. Sumner's not walking out here not knowing how to do that or how to resolve it, because that obviously was something that we did deal with before, and obviously it's given her quite the financial assistance and not having to pay. I think it was upwards of $60 or $70 a test on the weekend or something. But
where was she going on weekends to test?
Were you going to the hospital, Ms. Sumner, on the weekends?
Yes, the hospital's only place open on the weekend. Everywhere else, I have to call and make an appointment for a same-day test, and those are still $30 during the week.
Where do you get those tests done? In Coldwater?
It's all access care in Ludington.
Oh, I'm sorry. You're in Ludington. Okay, it's not Branch County then. It's what is that, Mason County? And Ludington doesn't have a regular testing facility. I mean, that's a pretty good sized town.
No, and I called the courthouse down here, and the only place they could direct me to was all access care. Otherwise, I'd have to drive over an hour away to go to like Reed City or something. But I don't go in that direction. I live in between Baldwin and Ludington, so I'm 30 minutes from either one, and neither place has anywhere else to go. I called everywhere on a weekend just trying to find a place, and the hospital was the only one that would accept me.
Where do you work at?
Beacon Specialized. It's an adult foster care.
But where is that located? Is that in Ludington?
Yeah.
All right. Well, I'm just going to leave it at this, that you need to work with the probation officer to figure out how you're going to test once a week. And I would make reasonable accommodations, but that's the most important part of this. It's why I've decided I rather than some jail time and the community service work that was recommended, I'd rather get the testing done and the counseling. And so work with your probation officer. It's just difficult for me to believe that there isn't something available in Ludington because it's a lot bigger town than Traverse City, I think.
It's very small compared to Traverse City. We have one main strip. And I mean,
well,
very small. And there's nothing available up here at all on a Sunday. The hospital's not even open for their lab testing on Sundays. And I paid over $100 for a test there on a Saturday. Okay.
Well, again, work with your probation officer on that. I hate to just leave it up in the air, but there's got to be a reasonable alternative. And Ms. Taylor will talk to me about that, and we'll come up with a plan anyhow. Okay.
Thank you, Your Honor. We just want to make everyone aware so that we weren't doing this after the fact.
Okay. All right. Well, yeah, thanks for bringing that up. And so make sure you contact the probation office after our hearing today. They'll go over the conditions of probation with you in more detail, answer any questions you have, including about where you're going to test and how that's going to happen. And there's a phone number on the pre-sentence report for you to call there. Okay. All right. Well, good luck to you, Miss Sumner. I wish you continued success with staying sober, and hopefully you have left this behind, and it's not going to be an issue for you anymore. So, okay. All right. We're all set then. Thank you, Mr. Graff and Mr. Hamlin.
Thank you, Honor.
Thank you, sir.
Is Rebecca Buck present? Rebecca Buck?
Your Honor, she's in the jail, but she is muted.
Ah, okay. Miss Buck, there's a clicker there. You can either try it yourself or get an officer to it. There's the officer. Okay. There we go. Thank you, officer. All right, Ms. Buck, are you able to hear me okay? Uh-oh, I can't hear you. Don't let that officer get away. The volume must be turned off. Yeah, officer, the volume seems to be turned off because I can't hear Ms. Buck.
Can you hear me now?
Now I can hear you. Thank you, officer.
You're welcome.
Okay, so this is People versus Rebecca Buck, file 214775ST. Mr. Johnson is here on behalf of Ms. Buck. And this is the date set for a plea. And Mr. Johnson, is that what your client wishes to do?
I would also like to be sentenced.
I believe she was already pled and sentenced. I'm here on another matter, actually, Ron.
Oh, okay. I'm sorry. I think I just assumed that because that you were representing Ms. Buck today because you spoke up, but you were just helping me out there. So, all right. The code here is for a plea, but is this a probation violation?
No, sir. I was hoping to plead and be sentenced today. I'm working with Community Corrections through 13th Circuit Court.
Okay.
And we are waiting on this to be completed before I can move on to that.
Did you see Ms. Drury's email to you?
Oh, I did.
Okay.
I see. Okay. All right. So let me get the letter that I received from Ms. Drury before we proceed any further, Ms. Buck. Okay.
Okay.
You're welcome. That.
Okay, so I have reviewed that letter again from the Community Corrections Office. And so it's my understanding that you wish to proceed to a plea, and the plea offer from the prosecutor is for you to plead guilty to count 2, dismiss count 1. Is that your understanding?
Yes, sir, it is.
All right, so count 2 of the complaint is a failure to stop after a collision, and the driving suspended second would be dismissed. Do you understand that you do have a right to an attorney, and the court would appoint one at public expense if you were unable to afford one?
Yes, sir, I do.
And you want to continue to waive your right to an attorney and represent yourself, correct?
Yes, sir.
All right. You were provided an advice of rights form, and let's see, you signed that back on March 31st, 2021. It described all your trial rights, including the right to a trial by jury. Did you read and understand all those rights?
Yes, sir, I did.
Do you have any questions about your trial rights today?
No, sir, I do not.
Okay. And has anyone used any force or threats or pressure or made any promises to you about what I would do if you were to plead guilty in order to get you to plead guilty and give up your trial rights?
No, sir.
Okay. So you're doing this of your own free will, correct?
Yes, sir.
All right. And I want you to understand that I don't really know too much about the facts of the case. I've only seen the complaint and Miss Drury's letter. And even though I think it's likely I'll go along with the community corrections and residential treatment and that, until I know all the facts of the case, I don't know how I'm going to sentence you. So I don't want you to think that that's a promise that you're going to get that. Do you understand that?
Yes, sir.
Okay. All right, then. So the complaint states that on January 18th, you were driving a Toyota, let's see, on US 31 in East Bay Township in Grand Traverse County. You had a collision with another vehicle. Is that true?
No, sir. I backed into a parked car in the parking lot at Seasons Motel.
Okay, well, it didn't say the other car was being driven. It just says it was either attended or unattended, but nobody was in the other car, right?
No, sir.
Okay, so nobody got hurt then?
No, sir.
All right, but you do admit you were driving your car, not on 31, I guess, but on private property. And that's when you backed into the Ford. Okay. And that was in East Bay Township, right? Okay.
Yes, sir.
And do you understand you were required to locate and notify the owner or operator of that vehicle or report the collision to the nearest or most convenient police officer if you couldn't locate the owner, and you didn't do that? Is that true?
Yes, sir.
Okay. All right, then to the charge of failure to stop after a collision, how do you plead?
I plead guilty, Your Honor.
All right, I'll accept your plea. Find it's voluntary, accurate, and understanding. The original charge will be dismissed, and let's go ahead to sentencing. What sort of criminal history do you have, Ms. Buck?
Multiple driving offenses. For the most part, I have some. I'm sorry, sir. I have some other things when I was in my late teens, early 20s, but for the most part, it's driving offenses. 3 drunk driving, several driving on a suspended. Use of marijuana in like 2006, but mostly driving.
All right, so I do see the bad check or uttering and publishing convictions back in the 90s.
Yes, sir.
And 1990 to be precise, so that's 30 years ago. And there's a breaking and entering in 1990 as well. Let's see. And then the driving issue started in 2005 with the driving suspended. And another drive suspended, and 2005 again. 2006 is operating intoxicated, 3rd offense.
I did complete sobriety clear after that.
Okay, so that was in 2006. Is that right?
I
that was a drunk driving.
2008.
Okay, it was reduced to a drunk driving second, so that would make sense. And then there's a driving suspended in 11, and operate without license, and 2014 drive suspended, and a couple more drive suspendeds. And then, okay, so the offense for which you're on circuit court probation right now is this 2020, December 2020 case. You were charged with assault or resist obstruct a police officer, and let's see, suspended license and habitual offender. And I'm going to assume you were probably intoxicated at the time that you were arrested for that offense too. Is that correct?
No, sir, I was not.
You were not. Okay.
I was not.
Obviously, the court's concerned about your problem with alcohol. And
yes, sir.
That's why Judge Power apparently would like to see you go to treatment, residential treatment through community corrections. And so
yes,
what
sir.
else do you want to tell me about this offense?
Well, sir, I panicked. I already had problems. I was already on bond for this other case that we were just talking about. You know, there's not a whole lot that I can say. It was a huge mistake. I shouldn't have been behind the wheel. You know, I'm going to do the best I can to try to get my license back. The last several times I've been in trouble, even this fleeing and eluding, and, you know, if I'd had my driver's license, I would have pulled over, and I've just panicked, and I left. You know, I need to pull everything back together, and, you know, like you said, Judge Powers willing to give me an opportunity to do that. You know, for quite some time, after sobriety court, I'd stayed sober, and, you know, life just piled in on me, and I believe I can get back there. I just need the opportunity to do so.
All right. Do you know whether the owner of the Ford had any out-of-pocket expenses as a result of this?
The vehicle was insured. The insurance covered it.
Okay, I'm going to accept that as true because I haven't received anything from the prosecutor to indicate differently. But I think what I'll do is leave restitution open for 30 days just in case there's something we're missing here. So I am going to, let me ask you this question. Have you been in jail on your circuit court case only, or do you have a bond in this case?
I was on bond. Well, I had court for sentencing in the circuit court case on the 23rd of April. I had assumed that I was going to get time served on that, so my husband posted my bail in this case on the 22nd. So the time on this case that I actually served was from March 31st until April 22nd. And I have been on bond in this case since then. Because I'm representing myself, I could not figure out how to withdraw that bond. I talked to the corrections officers. They all told me to talk to my attorney. Since I am my attorney, you know, the bond has been ongoing because I couldn't figure out how to retract it.
All right, but you were in jail on this offense from March 31st through April 22nd, correct?
Correct. Yes, sir.
All right. And, okay, well, this is what I'm going to do. The defendant is on a circuit court probation that certainly includes greater probation requirements than this court would impose on a fail to stop after a collision. The facts of what happened in this case are, let's see, it happened on January 18th at about 8:30 in the evening at the Seasons Inn. And it was one of the guests at the hotel whose vehicle was struck. And it was quickly learned that the defendant was the driver of the other vehicle, and that the defendant was observed driving in an aggressive manner, fleeing the property. And there was a concern, at least by one witness, that who said that the defendant was on something. That's how they put it. And this court's always suspicious when someone leaves the scene that maybe they're on something too. And apparently that was the observation of the witness. So the defendant has the opportunity apparently to enter community corrections and obtain residential treatment. Given the defendant's past, including a drunk driving third offense, the best thing for protection of society and for the defendant herself is that the defendant go through that residential treatment. So I don't want to stand in the way of that. The defendant has already served 22 days as a result of this offense. So what I'm going to do is impose straight 20 credit for time served in this case. Let's see, there'll be no probation, as all the concerns that this court would have are being addressed by the circuit court probation. And I'm not going to impose any fines or costs. The defendant's trying to get her life back together, and that's just going to be more of an obstacle and more of a setback that would perhaps cause even more concern for the public safety if she's not successful in this treatment. So I wish you good luck with that, Ms. Buck, and take it seriously this time. You really need to work the programs, listen to the counselors, and you can be successful here, but you've really got to spend the time and make it count this time, okay?
I am, sir. Thank you.
All right. Thank you. We're all set. Okay. Let's go to People versus Justin Deloy. Mr. Deloy, can you hear me okay? Let's see, is Justin Deloy present? I'm guessing that's the iPhone JD.
Correct, but apparently it doesn't seem like his audio is connected, maybe.
Okay,
Mr.
let
Deloy?
me see if he's been on for some time.
Yeah.
Let me see if I can send a chat message to him. I'm going to tell him to please try logging in again. Okay, so we'll go on to the next case until that problem gets fixed. This is People versus Shyla Bosak, and that is file 204573SM. Mr. Johnson is here on behalf of Ms. Bosak. Ms. Bosak, are you able to hear okay? You're going to need to unmute yourself, ma'am.
Yes, sir, I can hear you.
Okay, great. So this is the date set for a plea. Mr. Johnson, what is the plea offer?
Your Honor, the offer is that my client would plead to an added count 3 domestic violence first offense, and in exchange counts 1 and 2 would be dismissed.
You said domestic violence what?
First offense would be the plea, and the 2 counts of domestic second offense would be dismissed.
All right, and Ms. Blue is here from the probation office. Is that your plea offer, Ms. Blue?
That's correct.
All right, so, I see Mr. Deloy is back. Mr. Deloy, are you able to hear now? Or are you able to, can you say something?
You're muted right now, Justin.
Can you hear me now?
There we go. Yes, I can hear you just fine. I moved on to another case, but we'll come back to yours as soon as I'm done with this one, okay?
Sounds good.
All right. All right. So, Ms. Blue, is that the plea offer?
Correct, Your Honor. It'd be a DV first, and counts 1 and 2 would be dismissed.
All right. And most importantly, Ms. Bosak, is that your understanding of the plea agreement as well?
Yes, sir.
Has anything else been offered to you to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, sir.
Do you, has Mr. Johnson answered all of your questions to your satisfaction?
Yes.
Let's see. You understand that by pleading guilty, you will have a conviction for domestic violence, and that carries a maximum penalty of up to 93 days in jail.
Yes.
I need to go over your trial rights with you and make sure you understand those before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have a right to a jury trial to make that determination. Do you understand that?
Yes.
You also have the right to have the witnesses against you appear at trial to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand those rights?
Yes.
In addition, you have the right to testify at a trial, or if you choose, okay, if everyone who's not part of this hearing could mute themselves, please. I'm having difficulty hearing, so thank you. All right. Do you also understand that you have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way?
Yes.
And finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial. Any appeal would be by leave, not by right, meaning it'd be up to the appeals court whether to hear any appeal of your conviction or sentence. Do you understand that?
Yes.
All right, then let's turn to the complaint. And I forgot to ask, knowing all those rights, do you wish to waive them all in order to plead guilty to the reduced charge?
Yes, sir.
Okay, so the complaint says that on December 17th, you were at an address on Lilac Lane in Garfield Township in Grand Traverse County, and you were with Alex Rogers. Is that all true?
Yes.
How do you know Mr. Rogers?
He's my fiance and the father of our child.
Okay, and did you make an assault on Mr. Rogers?
Yes, I did.
What did you do?
I hit him.
And I take it you weren't just playing around, and that would have been offensive to Mr. Rogers.
Yes.
And you weren't acting in self-defense at the time, were you?
No.
Okay. All right, then, to the charge of domestic violence as a first offense, how do you plead?
Guilty.
All right, I'll accept your plea, find as voluntary, accurate, and understanding. The original counts 1 and 2 will be dismissed at the time of your sentencing, and that's going to be held on
June 24th at 9, if that works.
Okay, yeah, that's fine. June 24th.
All right, how about you, Mr. Johnson?
Your Honor,
I
am on vacation that day.
And you know what?
All right, no apology necessary. Everyone deserves a vacation once.
How about the 17th at 9:30?
That would be great.
Thank you.
All right, so it's going to be the 17th then at 9 o'clock also?
9:30.
9:30, okay. And Ms. Bosak, I'm going to need you to contact our probation office prior to that. Here's the phone number for you. Are you ready?
Yes.
231-922-6899.
Okay.
And please wait until 1 o'clock to give them a call. That way they'll have the paperwork from this morning's hearing. And I would like to ask, is there a need for an assessment in this case, Mr. Johnson or Ms. Blue?
The police report indicates no belief of intoxication or drug use, I believe. So I don't believe so.
Okay. All right. So we'll just get the pre-sentence investigation report then. And is there anything else we need to take up at this time?
No, Your Honor. I did have one question on another matter very briefly.
Okay, so feel free to sign off at this time, Ms. Bosak, and just make sure you call the probation office after 1 o'clock, okay?
Okay, will do. Thank you.
All right. What's your question on the other matter, Mr. Johnson?
Your Honor, we had a plea set on Aaron Dalzell for 10 o'clock this morning, and it's one of those cases where you had one of his cases and Judge Stepka had the other. We've entered pleas on both cases in Judge Stepka's courtroom, so I just wanted to make sure that that was properly off your docket today.
It is off my docket, so I don't see it. So thank you for pointing that out. Okay, so let's go to back to Justin Deloy then, and Mr. Deloy.
Yes.
Again, are you able to hear now? Yep. Okay, good. I can hear you too. So Ms. Conlon is here on behalf of Mr. Deloy. And let's see, Ms. Blue is here for the people. This is file 214913SM. And this is the date for sentencing on defendant's conviction of domestic violence with the understanding there would be a deferral. So Ms. Conlon, have you had an opportunity to go over the pre-sentence report with your client? And is it accurate and complete?
Yes, Your Honor, I do believe it's accurate and complete.
All right. So what would you like to say then on behalf of your client?
Your Honor, I think Mr. Deloy deeply regrets what happened with Ms. Donahue here. I think it's very out of character for him. He has, since I started representing him, has consistently expressed regret for what happened. Not that it's an excuse, but he was consuming alcohol on that occasion. He's not a big drinker. He doesn't have a good recollection of what happened, but he accepts full responsibility for it. I think that he'll do well on probation. He is employed. He does have, obligations he has to fulfill, and knows that he needs to stay out of trouble, comply with his terms of probation in order to keep his job and keep everything afloat. So he will do that, Your Honor. He's obviously very willing to pay the restitution to Ms. Donahue for the broken phone, and he will do that. And I don't think the court will see Mr. Deloy back for anything, Your Honor.
Okay, thank you. Mr. Deloy, I would like to hear from you. Is there anything you'd like to add?
I just want to say that tell Jennifer that I'm sorry for what I've done, and I'll take the blame for what I've done, and I don't plan on ever coming back here again. I think that's about it.
Okay, well, thank you. Ms. Blue, anything for the people?
Your Honor, I believe the victim might be on the line, and I don't know if she wishes to address the court or not. So if we could, I guess, ask her first.
Okay, so Ms. Donahue, can you hear me okay?
Yes, I'm here.
Okay, this is your opportunity to address the court before sentencing, and so if there's anything you'd like to add, I'd be glad to hear it.
Thank you, Your Honor. I just want to say that I appreciate Justin's apology, and I understand he's very regretful for what happened. I don't like being called a victim. You know, if I was, and I've been a victim my whole life, I was abused as a child and had a lot of things that had happened when I was younger. So I learned from my early age to grow from the things that have happened to me. And with everything that has happened, I feel I've become stronger. I don't allow myself to get into, you know, those kind of situations. I see, you know, the trigger points that had happened throughout the night that, you know, led up to the events that did happen. And I mean, it's definitely out of character for Justin to have done those things. We were together for 13 years. And I would like the judge, I would like you, Honor, to consider the fact that he, you know, lost a 13-year relationship. He lost his family. You know, he hasn't seen his daughter. And I would like them to rebuild that relationship and him be the father that she needs. And I hope the courts take that into consideration when sentencing. I feel like this, again, and just like Cynthia Collins had said, it is out of character for him to have done the things that he did. And I don't like being a victim. And so I took this and I grew from it, and I'm going to be a better person. And my girls are thriving as well. You know, I mean, they were upset and they had some issues at first, and we've talked about things, and they're growing and they're moving on as well. Not saying it was a good situation or that I'm happy any of it happened by any means. But that I feel that he's had quite a big punishment for his actions as it is. I don't know if the court necessarily needs to continue on with more punishments. That's all I really wanted to say.
Okay, well, I appreciate that. Thank you. Ms. Blue, is there anything else the people would like to add?
No, Your Honor. Thank you.
All right, so this is sentencing on defendant's conviction of domestic violence with the understanding there would be a deferral. Defendant actually pled no contest because he was intoxicated at the time of the incident. There's a 0.153 PBT in the report. And this was, as Ms. Donahue indicated, a 13-year relationship that ended, and there was some anger apparently going on. The victim was in the process of moving out when the defendant grabbed her phone, shattered it, destroyed it, and then pushed her down to the floor and started choking her. The defendant says he doesn't remember what happened because of his intoxication, and I suppose that's possible given he was almost twice the legal limit, and said he was stressed out and doesn't normally drink like this, but he had also used some marijuana prior to going to bed. And anyhow, the defendant, to his credit, has no prior criminal history. The victim, who I'm sorry, I'm going to refer you to you as a victim, Ms. Donahue, just for simplicity's sake here, but has indicated this was out of character for the defendant, and she knows him probably as well as anyone after 13 years of a relationship. And I don't get the impression that that Ms. Donahue is naive about abuse or about this relationship. She seems to be straightforward and practical about it. a lot of times in domestic violence situations, it's the victim who is willing to suffer additional abuse to continue a relationship. And that obviously didn't happen here, and Ms. Donahue has moved on, but would like to continue enough of a relationship so the daughters benefit from Mr. Deloy being around them. So let's see. Also, to the defendant's credit, he's employed full-time, and let's see, apparently pays his child support and otherwise seems to be a good citizen. And so given that this is a one-time sort of incident, I think the deferred sentence makes a lot of sense. So I'm going to place the defendant on probation for 1 year with the deferral. There is a fine of $100. The cost, I'm going to reduce that amount somewhat. I'm not sure why the 800, but I'm going to make that $400. There's a crime victims fund of 75. Judicial system fee is 50, and you'll need to repay the cost of your court-appointed attorney. That's $250. You can work out a payment plan with the court to get it paid off over the term of your probation. But make sure you set up a payment plan, or else they'll wonder what's going on. Okay.
Yep.
Okay. The conditions of the probation are going to be as follows. Given that I believe this wouldn't have happened, but for the alcohol, you're not to consume any alcohol. You're not to possess any illegal drugs or mind or mood altering substances, including marijuana, and you're not to be in possession of non-prescribed medication. You're not to reside where those substances are present. If you do have a prescription, provide a copy to your probation officer within 48 hours of obtaining that. You're not to reside where firearms or weapons are present, or be in the possession of firearms or weapons. And you're not to behave in a violent, threatening, intimidating, or harassing manner toward anyone. Be respectful of all court employees and care providers. The primary purpose of this probation is going to be so that it doesn't happen again, and that is to impose a condition that you attend and cooperate in the men's program, which is a 36-week program put on by the Women's Resource Center. And it will, I tell people it would be helpful for anyone to help control anger management problems. And so there would be a benefit to you whether this case had happened or not. But this is what I want to tell you, Mr. Deloy. You were choking. According to the report, it says you were choking Miss Donahue. And this could have very well turned into a 10-year felony offense. What you're looking at right now is very manageable. But if your temper gets out of control and you do something like this again, it could become very unmanageable fast. And so I would take this men's program very seriously, because you don't want something like this happening again, because the felony would just be very hard to recover from. So, okay. I'm going to have you take a minimum of 1 time per month random drug screens. There'll be discretionary testing for drugs and alcohol. I'm not sure why there are no PBT tests here. So I'm gonna add 4 times a month PBT testing, given that there was alcohol involved. Your probation officer will have the discretion to reduce that testing if you're doing well. I do want to get a benchmark urine screen tonight, and if that's clean, I guess I'll dispense with the once a month drug screens. If not, then we'll go ahead and impose that condition.
Now, what is that for? Sorry.
Oh, that's a drug screen. So it's a urine drop, and you'll need to get that done between 6 and 8:30 p.m. at New Directions Testing. That's out in Logan's Landing. And I'm going to give you a number to call after this hearing. Actually, it's in the report. And they're going to go over the conditions of the probation with you and answer any questions you have, and including about the benchmark screen, okay? You're not to have any contact directly or indirectly with Jennifer Donahue. Now, if at some point Ms. Donahue wants to allow contact between you and her daughters, I would probably start with some kind of like telephone or email or something like that. But I would have to hear it from Ms. Donahue that she wants that. And and Ms. Donahue, the way you could communicate that is through the probation office, okay? You're not to go within 500 yards of Jennifer Donahue's residence or workplace. Jail time is credit for 4 days. I agree with Ms. Donahue that there's been a lot of, I guess, punishment leading up to this, the end of a 13-year relationship, as well as having to, live without the daughter and all that. So I think credit for time served makes sense. Other than that, you need to notify the probation office if you have any contacts with law enforcement. That number, again, is in the report, but it's 922-6899. And you do need to contact them today, sometime after 1 o'clock today, please. And again, then go over the conditions of probation with you and answer any questions that you have, okay?
All right.
All right. I would allow for a review of the supervision, the probation, after you've completed all the terms and conditions. The law says the halfway mark, but since it's a 9-month program, I think that's the earliest that you'd be able to apply for that. So anyhow, we're all set for today, and good luck to you. And thank you, Ms. Donahue, again for your comments. Thank you, Ms. Conlon and Ms.
Thank you, Judge.
Thank you.
Yeah. All right, let's go on to People versus Jared Karl Black. That is file 214963SM. And is Mr. Black, are you able to hear me okay?
Yes, sir.
Carnegie's and Firestone.
Okay.
Yeah.
Is Mr. Travis?
Is a railroad baron.
He's MIDC.
He's MIDC,
He'll be
okay.
here shortly.
Hang on just a second. I'm getting a lot of extra
Technology.
noise here.
Yeah, with that, with technology, with the.
Okay, I think I took care of that. So, Mr. Black, I need you to hang on here. Mr. Travis is in another courtroom right now, but when he gets here, we'll take up your case. So, let's see. The next thing I have on the docket are preliminary examinations starting at 11 o'clock. Let's see, officer, who do we have in the jail? I need you to unmute there. There we go. Okay.
Can you hear us?
Yes, I can hear you now. Who is this?
This is Miss Stingley.
Stingley, okay. So, Ms. Stingley, we're waiting for your attorney, Mr. Warden. We got about 5 minutes here, so I'm gonna take a break until then. So we'll be back at 11 o'clock, and hopefully Mr. Travis will be back for your case there, Mr. Black.
All right, sounds good.
Okay. Who do we have? It says Xavier's Galaxy S10. If you want to unmute yourself, could you identify yourself, sir?
Michael Leatherman.
Who?
Okay, Michael, what was the last name?
Leatherman.
Leatherman.
Leatherman,
Were you
okay.
before the magistrate?
For Brandy Harbert.
Oh,
He might be a witness, someone of our.
I'm a witness.
Ah, you're a witness. Okay. Well, thank you for being here, Mr. Leatherman, and we'll get started with the hearing then in a few minutes. Okay.
Okay.
I'm going to mute you until that time because I can hear the wind. It's louder than you might think on my end anyway. So, all right. And Miss Mistily, let's see, you're here on Ricky Bowker, and is he? I understand that's going to be a misdemeanor plea. Is that correct? Oh, you're muted.
Sorry, that's correct, and he is in jail.
Oh, he is in jail right now. Okay. Well, we've got Miss Stingley here, and it's my understanding that's going to be a waiver. And as soon as Mr. Warden gets here, we'll take care of that, and then we'll move on to Mr. Bowker.
Okay, real good. Thank you.
Thank you.
I don't know who this is. I'm not sure. Why aren't there kids in there? Kid out of there. The hell? So last place I didn't want my kid on the court now. What is that? Lady still doing here that's back there? The one that talks to dead people. The one that talks to dead people. Who? That Catherine level here. What? She. Come on, man. No. No. Yeah, that's what she says. She has a book she's been writing. She keeps being scared that you guys take it. I don't know what she says in that book.
wait, you guys, we're live. We can hear you and we're live, so people out in the public can hear your conversation. I'll be right back.
Hey, Tammy?
She stepped out for a second.
Oh, okay.
Do we have a prosecutor here?
Guess not.
Yeah, I'm here.
Oh, Ms. Bruce. All right.
Oh, there you are. You were hiding on. You were.
I'm just hanging in the background.
Yeah, lurking. You might do that on Facebook.
Hey, Tammy.
Mr. Ward. Yeah.
Hello there. I'm Bill Barnett. I'm on the Brandy Nybert matter. She's trying to call in. Hello. She's having my client Brandy is having some issues calling in. We're not having a preliminary examination. We're waiving. I see Mr. Leatherman. He's the alleged victim on the case, or the complainant. He's on his YouTube here. However, we're waiving. But she's having issues getting herself in on Zoom.
Okay.
And my staff's working with her.
Okay, and does your staff have our virtual courtroom instructions, including how to, if she can't get on just with a video and audio, she could just call in as well?
We've sent her everything we received, so I'm guessing yes. Could you just give me that number in case that we come back to that issue?
Sure. So for a phone call only, it's 646-876-9923. And she joins using the same ID number. And I'm happy to read that to you as well if you'd like.
Hang on a sec.
Do you want? I'm sorry, sir.
Hang on just a second.
Sure.
Is it 926? Is that the number? 763-128?
No, the meeting ID number is the 242-305-0413.
Okay. I'm going to go take a break and see if I can get her in.
Okay, that
I'll
sounds
be right
good.
back. Thank you for your
Sure.
help.
Oh, you're welcome. Mr. Warden, are you in? Are you hanging out in the background?
I don't see him.
Okay, jail. Can you get the corrections officer for me?
What's going on?
Hello.
Hello.
Would it be hi, could you guys swap out Miss Stingley for Mr. Bowker, please? We have Miss Mistley here waiting and Mr. Warden's not here yet.
Volker?
Yes.
Yeah. Ricky Bowker. Thanks so much.
Tammy?
Yes, Mr. Barnett?
Thank you. It looks like she's Galaxy A21 and she's connecting to audio right now. We have her video.
Okay,
Waiting.
fantastic. Let me just, she's Brandy Nybert, right?
Yes.
Okay, I'm gonna go ahead and change her name then. Glad she got in. That's great.
Yes. Brandy, can you hear us?
Yes.
All right. Just sit tight. We're being recorded right here, so sit tight, okay?
Okay.
Okay, and is this Mr. Bowker then? Nope, that's not Mr. Bowker.
The officer's going now.
Mr. Leatherman, you're free to stay if you'd like, but you are released from your subpoena, so you don't have to stay.
Oh, I hear Mr. Warden in another court. Okay. Officer, did you need something?
No, I'm just waiting for the other officer to get the person you need.
Okay. All right. So we're ready on the Nyberg case. Verify that the defendant's here. Yeah, we have Ms. Blue. It doesn't look like the defendant, Mr. Bowker's here, but we do have Mr. Barnett on Nyberg that we could do for a waiver, and Ms. Blue's here. Mr. Bowker should be coming shortly. Oh, it's Brandy Nyberg is Mr. Barnett's client. You can call the Nyberg case, Judge, if you're wanting to get started.
No, you know what happens?
Huh?
As soon as I call Nyberg, then the jail opens the door and it's loud for the next 10
All
minutes.
right.
So I'm gonna wait. See, if I listened to you, I would have called Nyberg.
I would have.
And then I'd be
have.
frustrated.
Good move, John.
Okay. All right. Good morning, Mr. Bowker. Are you able to hear me okay?
Yes.
Okay, so this is file 2151889FY, People versus Ricky Bowker, and Ms. Bensley is here on the defendant's behalf. Ms. Blue for the people. And it's my understanding the defendant is going to plead to a larceny, 200 to 1,000, and attempted B&E, a coin device, both one-year misdemeanors. The original charges would be dismissed. Is that a correct statement of the plea offer, Ms. Mistley?
It is, Your Honor.
In addition, it says the defendant is responsible for all the restitution for this incident. Is that also part of the agreement?
It is.
Okay, Ms. Blue, can you confirm that's the plea offer?
That is correct, Your Honor.
Okay, and most importantly, Mr. Bowker, is that your understanding of the plea agreement?
Yes, sir.
Do you understand that by pleading guilty, you will have a conviction for larceny 200 to 1,000 and attempted B&E, a coin-operated device, and that those both carry up to 1 year in jail, albeit they would be concurrent. So the most you're facing is a total of 1 year in jail. Do you understand that?
Yes, sir.
You've also agreed as part of this deal to pay all the restitution that's in the police reports, I guess. So is that true?
Yes, it is.
Okay. All right. Has anyone offered you anything else to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No.
Has Ms. Mistley answered all your questions to your satisfaction?
Yes.
I need to go over your trial rights with you and make sure you understand all those before I'm able to accept a plea, so please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have a right to a jury trial to make that determination. Do you understand those rights?
Yes, sir.
You also have the right to have the witnesses against you appear at a trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand all those rights?
Yes, sir.
In addition, you have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand that?
Yes, sir.
And finally, by pleading guilty, you give up the right to appeal that you'd have if you went to trial. And any appeal from your conviction or sentence would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear your case. Do you understand that?
Yes, sir.
All right. Knowing all those rights, then, is it your desire to waive them all in order to plead guilty to the reduced charge?
Yes, it is, sir.
Okay, so I'm going to turn to the complaint then at this time. And we need to establish a factual basis for both of the reduced charges. And let's see. Okay, it says that on February 20th, in Acme, Michigan, the owner of the touchless car wash there said someone had stolen some quarters from his business. Was that you?
Yes, sir.
Okay, and it says you broke into a coin machine on a vacuum machine. Is that what happened?
Yes, it was.
Okay. And it says you took it at least, well, it says $1,200, but did you take at least 200?
Yes.
Okay. And let's see.
May I briefly, Your Honor?
Yeah, go ahead.
Thank you. And Mr. Boker, is it true that you broke into that coin-operated machine?
Yes.
And from that machine, you then took quarters. Is that correct?
Yes.
And that was a value of at least $200 in quarters, right?
Yes, it was.
And you did not have permission from the owner or operator of the business to enter that coin-operated machine, correct?
No.
Or to take any of the quarters from that coin-operated machine, is that right?
Right.
Okay, thank you.
All right, well, I'm satisfied the facts that establish both crimes have been established. So then to the charge of larceny, 200 to 1,000, how do you plead?
Guilty.
And to the crime of attempted breaking and entering a coin-operated device, how do you plead?
Guilty.
All right, I will accept both your pleas. It's obvious that they are voluntary, accurate, and understanding. So next thing we're going to do is set this for sentencing at a later date, and I would like to get a pre-sentence investigation report. Ms. Odom, you want to work with Ms. Mistley on a date?
Your Honor, you may want to be aware that Mr. Boker is going to be sentenced in circuit court tomorrow on a possession of narcotics case. He has guidelines right now scored of 0 to 17 in that case.
Okay. Well, it sounds like there's a wide range of things the court could do with a 0 to 17 range. So,
yes.
So I think we'll just keep this on regular track, and you know, sentencing maybe in a couple of weeks here, and we'll have more information to work with as far as my sentence. So go ahead and pick a date then, Ms. Odom.
Okay, June 14th at 9.
Okie dokie, that's great. Thank you very much.
All right, thank you. We're all set, Mr. Boker. Can you please let the correction staff know that you're all finished? And we'll get Ms. Stilwell back here. All right. At this time, I am going to go to, oh boy. I'm going to mute the jail here. All right, there's Mr. Warden, but we've had Mr. Barnett waiting for some time, so I'm going to go on to that case first. So this is People versus Brandy Nybert, and that is file 215021FY. Mr. Barnett is here on behalf of Ms. Nybert. Are you hearing me okay, Ms. Nybert?
Yes.
Yes. Okay, and we have Ms. Blue here for the People. And it's my understanding this is going to be a waiver. Is that correct, Mr. Barnett?
Yes, it is, Your Honor.
All right, and has there been some offer made to get the defendant to waive that's contingent upon the defendant waiving her right to a hearing?
It's mentioned in the process of the plea agreement. We do have the matter resolved, and part of it was to have her waive today. And we accept that. We wish to do so. She understands her rights and is willing to give up this hearing to proceed to circuit court to enter her pleas.
All right, so the offer is already stated in the probable cause form. And Ms. Nybert, other than that offer that's been made, have you been offered anything else to get you to plead guilty, or have you been threatened, forced, or coerced in any way? I'm sorry, not to plead guilty, but to waive your hearing today?
No.
No, okay. Ms. Blue, are the People agreeable to the waiver?
They are, Your Honor.
All right, so the defendant has waived her hearing. The defendant is bound over to the circuit court to appear next on June 2nd. That's at 1 o'clock, and that is the pretrial conference. And defendant is bound over as charged in the complaint. Are there any issues at this time regarding the bond?
No, Your Honor.
Any other matters we need to take up before the arraignment?
Not from the People.
No, Your Honor.
Okay, so Mr. Barnett, do you care to go forward with the circuit court arraignment at this time?
We do, Your Honor. She's going to stand mute to all charges at this point, waive a reading as well of the charges.
All right. And you've obviously, no doubt, informed her of the maximum penalties and the nature of the charges, correct?
I have, Your Honor, on several occasions. Yes.
All right, then. We're all set then for today, unless there's anything else.
No, Your Honor. Just double check. The court said June 2nd at 1 p.m. for her circuit court pretrial on this case.
That's correct. June 2nd, 1 p.m.
Do you know which court,
right.
which judge that is?
Oh, we do not know. In fact, I think the circuit court makes a decision after it gets bound over. So,
all right. Thank you. We're all set,
Okay.
Your Honor.
All right. Thank you. Good luck, Ms. Nybert. All right, let's go to this Stingley's case. And Ms. Stingley, there's a remote control there. If you could try to unmute yourself, I'd appreciate that.
Your Honor, if I may have a brief breakout room with Ms. Stingley.
Okay, let's make sure she's able to unmute herself first. There she goes. Okay, so I'm going to put you in a breakout room with your attorney. Okay, Ms. Stingley?
Yes, sir.
All right, so let's go to Mr. Black's case. We now have Mr. Travis present, and that is file 214963 SM People versus Jared Karl Black. Ms. Blue is here on behalf of the people, and this is the date set for a plea. Is that what your client still wishes to do, Mr. Travis?
It is, Your Honor.
All right, and what is the plea offer, if any?
Your Honor, the offer is if he were to plead guilty to count 1, which is attempted larceny in a building charged as a 1-year max. Counts 2 and 3, which are attempted financial transaction device stealing, retaining without consent. 2 counts of that would be dismissed.
All right, Ms. Blue, is that a correct statement of the plea agreement?
I believe so, Your Honor.
All right, and most importantly, Mr. Black, is that your understanding of the plea agreement?
Yes, it is, Your Honor.
All right, do you understand that by pleading guilty, you will have a conviction for attempted larceny in a building, and that carries a maximum penalty of up to 1 year in jail?
Yes.
Has anything else been offered to you other than dismissal of counts 2 and 3 to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, Your Honor.
Has Mr. Travis answered all your questions to your satisfaction? I didn't catch that.
Yes.
Okay, and let's see, I do need to go over your trial rights with you, make sure you understand those before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have a right to a jury trial to make that determination. Do you understand those rights?
Yes.
You also have a right to have the witnesses against you appear at trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if necessary. Do you understand that?
Yes.
In addition, you have the right to testify at a trial, or if you choose, to remain silent, and that silence cannot be used against you in any way. Do you understand that?
Yes.
Finally, by pleading guilty, you give up your right to appeal that you'd have if you went to trial. And any appeal would be by leave, not by right, meaning it would be up to the appeals court whether to even hear any appeal of your conviction or sentence. Do you understand that?
Yes.
So knowing all those rights, do you wish to waive them all in order to take advantage of the plea offer?
Yes, Your Honor.
All right, then let's go to the complaint in this case. And let's see. All right, the complaint alleges that on February 19th, you were at a location described as 2384 North US 31 South in Garfield Township and Grand Traverse County. Is that true? And what's that building or residence?
I'm pretty sure that it's the Shell station. And yes, I was there. It's the Shell station on South Airport 31.
Ah, okay. And says here that you attempted to break into, or excuse me, you attempted to steal something. It says something about committing a crime by stealing a wallet from a restaurant. Is that what you did?
Yes.
Okay, so maybe it wasn't the Shell station, or I didn't catch that.
The Applebee's next to the Shell station is where I obtained the wallet.
Ah, okay. And were you caught with it at the Shell station? Is that what happened?
Yes.
Okay. All right. So let's see. So you took the wallet, and it didn't belong to you, and it was inside the Applebee's when you took it, correct?
Yes, Your Honor.
All right. Do you know whose wallet it was?
Alex J. Swartout.
Did you know Mr. Swartout before you took the wallet?
No, I did not.
Okay. All right. Are the parties satisfied that the facts of a attempted larceny in a building have been established?
Yes, Your Honor.
Yes, Your Honor.
All right. Then to the charge of attempted larceny in a building, how do you plead?
Guilty.
All right. I will accept your plea. I find it's voluntary, accurate, and understanding. Let's go ahead and set a date for sentencing.
June 14th at 9:30.
Thank you.
All right. So we'll be back here on June 14th at 9:30. I'm not sure if we'll be in person or zooming in like this, but you'll get a notice in the mail explaining that. Prior to that time, I do need you to call our probation office, Mr. Black. They're going to interview you, give me more information about this case so I can come up with an appropriate sentence. Have you got a pen handy?
Yes.
Just let me know when you're ready.
I am ready.
Okay, the number is 231-922-6899.
Okay.
Okay. And just give them a call after 1 o'clock today, please. That way they'll have the paperwork from this hearing, and they'll set up an interview time. Is there anything else we need to take up at this time, Mr. Travis?
Nothing further, Your Honor. Thank you.
All right, we're all set then. We'll see you back on the 14th, Mr. Black.
All right. Thank you, Your Honor.
Yep. Okay, so let's go back to the Stingley case. I'll need to get Miss Stingley out of the breakout room. Let's see how long it takes this time. It's been taking up to 40 seconds.
Okay, that one's taken a really long time.
Yeah, that's a record, 65 seconds. All right, so Ms. Stingley is back, and Mr. Warden is here on Ms. Stingley's behalf, file 215-187-FY. Ms. Blue is here for the people. It's my understanding this is going to be a waiver today, Mr. Warden, is that correct?
That is correct, Your Honor.
All right, and Ms. Blue, are the people agreeable to a waiver?
We are, Your Honor.
Okay, and Ms. Stingley, your attorney has advised you to waive the hearing, but is that what you want to do?
Yes, Your Honor.
Okay, and has anyone promised you anything or made any threats or force or coercion to get you to waive your hearing today?
No, Your Honor.
All right. So the hearing has been waived. And the defendant is bound over on the charges in the complaint. The next hearing will be on June 2nd at 1 p.m. And that's the circuit court pretrial. Are there any issues we need to take up before we go to the circuit court arraignment?
Yes, Your Honor, I'd like to make a motion.
Okay, that regarding bond?
Yeah.
Okay, so go ahead.
Your Honor, Ms. Stingley is on felony parole. And I know that's not a great start to a bond motion to inform the court that she's on felony parole. But because she is on parole, she is actually on dead time right now. Shannon Wagner is her agent out of Kalkaska County. And Ms. Wagner has indicated that she could get Helen into some programming. I think that would probably be long-term the right thing for Helen. She did have a significant amount of clean time before this matter came up, which, you know, without making it admission, sure looks like a relapse. The alleged facts are that she was found with 1 gram, 1.47 grams of methamphetamine in her purse. I'm asking the court to consider changing the $25,000 cash or surety bond to a $25,000 PR bond, understanding that, again, she's on a parole hold. So she's not going anywhere unless MDOC lets her go somewhere. This simply gives that as the possible option.
Well, I don't know. Let's hear from the prosecutor. Ms. Blue, anything for the people?
No, Your Honor.
Well, let me take a look at the praxis report here. I mean, my concern is that, you know, I would assume the circuit court would be aware of what the bond is in this case. And if it took action on the parole hold and the court was assuming that she wasn't going anywhere on this case, that would be on them. But But at the same time, it would be highly unusual to have a PR bond in a case like this, especially with someone that's on a parole hold. Give me a minute to look at the praxis report. Is it
frozen? I was frozen.
Just a minute.
Yeah, it's better.
To reconnect, it says. Okay. All right. Well, this is something I think is better taken up by the circuit court. The current bond is 10,000 cash or surety. And I think if there's a good argument for why the defendant should be released on bond, I think the current bond is appropriate. But if it's to get into treatment or for some reason like that,
It's 25,000, Judge. It was upped on 5/3.
Oh, it was?
Yeah, just so you know.
On 5/3. Do you know why it was increased to
I
that?
don't, but I can see if I can find out. I don't. Perhaps Mr. Warden knows. I don't know.
I don't know, Your Honor.
All right. Well, either way, I think I would rather have the circuit court take that up. So I'm going to deny the request. All right. Is there anything else we need to take up before the circuit court arraignment?
Get it to a 10%.
That's going to be up to the circuit court, ma'am. And so you'll be in front of the circuit court on June 2nd. That's in about 10 days away or so. And it doesn't sound like you're going anywhere anyhow, but since this is going to be a circuit court matter, I would rather leave it up to the circuit court what they want to do. Okay, so Mr. Warden, let's go ahead with the circuit court arraignment.
Yes, Your Honor. We would waive a reading of the felony information and ask the court enter not guilty pleas at this time. Ms. Stingley is aware of the charges pending against her, the maximum penalties involved.
All right, so I will enter not guilty pleas on the defendant's behalf. And let's see, if there's nothing else, we're all set for today. Thank you, Mr. Warden, and good luck to you, Ms. Stingley.
Thank you, Your Honor.
All right, so I have two other preliminary examinations.
We only have Mr. McCauley.
Okay, so Nybert is,
We did Nybert.
let's see, we took care of Nybert.
That was a waiver.
All right, is McCauley in jail then?
He is not.
No,
he
he
is
actually-
bonded out.
On the 17th, he got a bondsman. So just a few days ago, really.
And Ms. Nybert, I see you were still on the call, I think. You're free to log out at this time if you like. I just wanted to make sure you were clear about that. You don't have to, but you're free to go if you like, okay?
I just heard a couple of the cases. I'm reconsidering my lawyer.
Okay, well, I'll tell you what, you should talk to your lawyer about that. If you think you need a new lawyer, don't be afraid to tell Mr. Barnett. And he will file a motion to withdraw. But you need to talk to him first. And if he doesn't want to do that, I don't have jurisdiction over the case at this time. So you'd have to bring that up with the circuit court, okay? But if you let him know there's a problem, he will do that. Okay, so let's see, we're on file 202745FY, People versus Gabriel McCauley. And Ms. Blue is here on behalf of the people. Mr. McCauley, as I understand it, is unrepresented and he is not present. Am I wrong about that? Mr. McCauley, are you there? Okay, so it is now 11:42 a.m. The defendant has failed to appear for this 11 o'clock hearing. And therefore, Ms. Blue, are you requesting a bench warrant?
Certainly, Your Honor. There's been multiple issues with bond already. And it's almost a year-old case, so I would definitely be asking for a bench warrant at this point so we can get it moving forward.
Okay, so I will issue a bench warrant. There will be no bond at this time. And
I just want to let you know, way back in April 2020, he keeps saying that he's going to hire Mr. Slocum. If you notice, he has no lawyer. So now we're here.
And that's part of our hesitation on talking with him, is every time we talk to him, he says he's going to get an attorney. So I don't want to have too many conversations with him if he has the intention of retaining an attorney.
all right, make sure you remind me of that the next time we have him here in court, Ms. Blue.
Will do.
And, Ms. Odom, and we'll address that situation. So, okay, we're all set. Thank you, Ms. Blue.
Thank you, Your Honor. Have a good day.
You too. All right, we will be in a